Hello, everybody. This is a publication called The Empty Closet, and it is based out of Rochester, and it does get some reach up here, as apparently, since I live in Buffalo, it definitely does reach out here. I want to first talk about a rabbi speaks at opening of JCC exhibit on Nazi persecution of homosexuals. He basically, summing it up, he basically said that we must now oppose homophobia in every arena of our existence, of our lives. Because he says of the civil rights movement of the 1960s that it was not until the white religious community got rid of its bigotry, hatred, and set aside the differences, and sat in the Congress of the United States and said, we demand the Civil Rights Act of 1964. Similarly, LGBT rights are not going to happen unless we have the straight community and the religious community behind us. And this is so true because that's one of the reasons why I believe that, gay and lesbian clergy and gay and lesbian affirming clergy are definitely needed. He goes on to say that Hitler did not take office with the use of force. He was voted into office, and the German people overwhelmingly voted the Nazis into office. And they somehow believed that equal rights of all human beings could be voted on. So that's the one part there that I feel is definitely worthy of mention. Then the New Mexico Supreme Court protects non-biological mom in custody cases. On June 1st, the New Mexico Supreme Court issued a decision recognizing important new protections for non-biological mothers who are raising children with a same-sex partner. The persons, Bonnie Katerji and her partner, Tanya King, were in a committed long-term relationship and decided to raise a child together through international adoption. Because they could not adopt jointly due to discrimination against same-sex couples, only Tanya could legally adopted their child from abroad. So even though Bonnie did not adopt the child, she supported the family financially, and they co-partnered. And Taya, not Tanya, moved to Colorado with her daughter and tried to prevent Bonnie from having any contact with the child. And that's when she filed with the New Mexico District Court, and the New Mexico District Court ruled against her. The New Mexico Court of Appeals ruled that New Mexico law only allowed fathers, not mothers, to establish parentage based on these facts, and that Bonnie may seek visitation as a non-legal parent. But basically, the New Mexico Supreme Court affirms there is a New Mexico Uniform Parentage Act, and it said because she only openly held out the child as her own and established a personal, financial, and custodial relationship with the child. The court noted, our legislature has recognized that there will be many situations in which someone is caring for a child that has not taken the legal steps to legalize that relationship. And they stated because parental rights are not automatically conferred when there is a biological relationship, but when an alleged parent has taken the responsibility of caring for that child. This is definitely a best interest of the child argument, and of course I agree. The NCLR Family Protection Project Director Kathy Sakimura said, "This is a tremendous important decision for our client and for many other families and children in New Mexico who have created loving, stable parent-child relationships that are not based on biology. The New Mexico Supreme Court affirmed that the parentage statutes must be applied equally to protect children, regardless of the sexual orientation of their parents or their marital status or gender. They're grateful that the court has issued a thoughtful, well-reasoned opinion and will no doubt serve as a powerful model for other courts in other states." Which brings me to North Carolina. This year, the North Carolina ACLU has brought suit for 6 couples who have been particularly harmed by a 2010 ruling that said that non-biological parents do not have the right to adopt for a second parent adoption. So I'm hoping that the New Mexico decision will have some sway in North Carolina, and I am hoping that soon Amendment 1 will also be going into the wastebasket as well when DOMA is overruled too. But anyway, or Speaking of DOMA, it has been case conferenced this week, and I am hoping to hear something. I do believe I do believe I've heard some news that Prop 8 case and the DOMA case are not on the roster. So if it's not on the roster, maybe it will apply to that second district and the first district that DOMA is unconstitutional and join enforcement. In other words, not enforce DOMA for those specific states. But Iowa is covered under a completely different court, and I believe California, the Ninth Circuit, would also, I believe, do the same with those states as far as DOMA is concerned. So mainly the Midwest and most of the South would be uncovered by such a DOMA ruling if they simply do not hear, the Supreme Court does not hear those cases. So, see you later, YouTube. Bye-bye.